Hello, everyone. I want to first say welcome and to this webinar, and I hope you're staying safe and healthy during this pandemic. We received a lot of questions around the Paycheck Protection Program, and Butzel Long is here to help clear up some of this confusion. Feel free to ask questions during the webinar in the question box, and we'll be reviewing these at the end of the webinar. If your question does not get answered during the webinar, a BBB representative will be following up with you. I also want to thank the three representatives, Bernie, Justin, and Brett, who are sharing their knowledge and expertise with us today. I'm going to go ahead and turn it over to you guys to get started.
Thanks so much, Brianna, and welcome everybody. Happy Thursday. My name is Bernie Foos. I am with Butzel Long, obviously. I'd like to first introduce the rest of the team. On this webinar is Justin Klimko. Justin is on the board of directors of Butzel Long, along with myself. He also is the president of Butzel Long. When he's not dealing with PPP and CARES Act emergencies like we're all dealing with right now, he is generally speaking a corporate attorney, emphasizing on mergers and acquisitions and all things fun and corporate. My other colleague is Brett Miller. Brett Miller is another partner of ours. Brett is our labor and employment guru. Again, he is really on point right now, given a lot of the dynamic and discussions that employers and businesses like you guys are facing in terms of whether you're going to get this loan, whether you qualify for it, and how you balance that with some employment decisions that are hot to trot right now. And again, my name is Bernie Foos. Again, right now, the last few weeks, we've been really focused on dealing with the CARES Act and the PPP and those kind of emergencies. But when things are usually normal, I specialize in emergency litigation, focusing mostly on business disputes, protecting companies, their confidential information, their trade secrets, and their most valuable assets and relationships. But for today's purpose, and really the last few weeks, you have the trifecta of CARES Act and PPP experience between business litigation, myself, corporate with Justin, and labor and employment with Brett. So we're really looking forward to updating you all on what you really need to know about the CARES Act today. So a few quick administrative things right off the bat. Much like many of you, I am working from home. So if you hear some screams, some kicking, some screaming, things like that, those are my 4 coworkers under the age of 10. So I apologize ahead of time if you hear some of those noises. Please don't judge me, and I will not judge you for likely being in your pajamas for the last 4 weeks. Fair enough? So let's get into it. I'm sure most of you are at least somewhat familiar with the CARES Act. And the potential of there being, quote, free money, end quote. And that's really the focus of today, navigating the Paycheck Protection Program. So what are we going to talk about today? I want to give you just a quick overall breakdown of the CARES Act itself. Justin and I will both go through the Paycheck Protection Program itself, who is eligible, what it takes to be eligible, what you can use the loan for, and Justin's really going to dig into the forgiveness component. This is where the, quote, free money comes in. Most folks are recognizing that you can get this loan, and if you use it for the appropriate purposes, it may be forgiven, turned into a grant, free money. But there's a lot of nuances within that. Justin has really been working behind the scenes to get a good understanding of that aspect to it, because that certainly affects the business decisions you're going to make, whether to keep people employed versus letting them go. And if this is truly free money to a certain extent, that obviously affects the business decision. Then we're going to get into some common questions that we are really hearing from our clients and the employers around there, surrounding the CARES Act, taking the money, and whether they can still go forward with RIFs, layoffs, furloughs, or if those decisions that have already been made are going to adversely affect them and their ability to take advantage of the CARES Act and a potential PPP. And then for some of you out there who may not be eligible for the Paycheck Protection Program, or for whatever reason, maybe you can't get access to the money. There's a variety of reasons why things may not take place right now. We're going to briefly touch on some potential other options for you. And then, of course, as Brianna alluded to, we'll be willing to take questions at the end. And if we don't have enough time to answer all those questions, whether it's through Brianna or our CARES Act team at Butzel Long, we'd be willing to have a discussion with you offline to kind of delve into it further. So let's kind of get into it. Bear with me one second. All right, so the CARES Act. This is the biggest, largest, you name it, economic relief package in the American history. You can call it a stimulus package. You can call it a rescue package. It is massive. Not only is it the biggest, though, for all intents and purposes, it's the fastest package that has been approved and that they're trying to implement. Because of that, it being the largest monetary rescue package, and they're trying to expedite this as quickly as possible, it has really caused a lot of confusion, and there have been a lot of roadblocks that have really kind of gotten the program off to a rocky start. But in terms of numbers, you can see it right here on the screen, $2 trillion. 600 billion of that is supposed to be going to individuals. They're working on that right now. We're not going to get into that today, but they're at least hoping a lot of this individual money, the paychecks that people are expecting to get from the government, the direct deposits, should be coming in the next few weeks. 500 billion of that was geared towards what they call larger corporations. I'll touch briefly on that at the end, but that's not really the emphasis of today's webinar. 377 billion for small businesses, and that's really the heart of what we're going to be talking about today. 349 billion of that is for the Paycheck Protection Program. And if any of you have been following the news, whether it's paper or on TV, today the Senate is going to try to add 250 billion more to the 349 billion pot for the CARES and PPP program. We'll see where that goes. And then, of course, there's 340 billion for state and local governments and 180 billion for public services. Again, today our focus is really small and mid-sized businesses, and it really is a broad definition under the Act and what we're talking about. Of course, when you say small business, you think of the mom and pop shops on the top of the screen there, the restaurants, folks who only employ a few people, the restaurant industry, franchise industry, things like that. But it also includes a lot of suppliers. If you look at the bottom left corner, people who manufacture parts and supplies for the automotive industry, or really any kind of manufacturing. Those kind of companies that have 500 employees or less, and sometimes more, actually are deemed to be a small or mid-sized business. And even professional services firms, companies who might not be on Main Street there on the top or in the manufacturing sector. A lot of companies out there who your classic white collar jobs, so to speak, some of those qualify as small and mid-sized businesses. So the Paycheck Protection Program, I'm going to get into who is eligible. That's the biggest concern a lot of folks out there have is, do I qualify? If you do qualify, what can the loan be used for? Then will the loan be forgiven? Again, this is that free money component. There's a lot to it from an overall perspective. If you keep people employed and you don't cut their wages, in general terms, it should be forgiven, but there are a lot of nuances that you need to understand and be prepared for. There are some unanswered questions, and again, Justin will dig into that. What is the process, right? That's just from a practical standpoint. I'm going to go over that with you. It all sounds good. Maybe you're eligible. It sounds like you can get the money. What the heck do you do? Especially with some of the rumors floating out there, and they're not rumors anymore, that the banks aren't taking new applicants, especially the big banks. So how do you navigate that process? And then look, a lot of you obviously are employers. You've got tough decisions to make right now. Cash flow for many businesses out there are tight. So you are probably considering, or at least analyzing, a potential RIF, a furlough, those kind of questions. And when you time those, when you go through with those, and Brett Miller will be able to get into that with us. So who is eligible under the Paycheck Protection Program? It's really two prongs. Prong number one, any business, a startup, a veteran organization, or a nonprofit, if you've got 500 employees or fewer in the United States, you would normally be eligible for this program. Okay, so if you have a restaurant out there with 12 employees, if you've got a new startup with 20 employees and it's US based, you'll probably be eligible under this program. What the CARES Act did is it really expanded the definition of a small business for SBA purposes, and it ranked it right up to 500 employees or less. So really, most businesses out there, if you're at 499, you will likely qualify for this program. Now, there are, prong number two, you could have more than 500 employees if you meet the definition of a small business with a NAICS code. So let me give you an example. We've got some clients who are motor vehicle parts manufacturers. Some of them have 530 employees in Michigan and beyond in the United States. So at first glance, they thought they were not eligible. But if you plug in this code, and this code can usually be found on the first page of your Michigan tax return, you plug that into the SBA standard system. And for example, certain auto manufacturers, a parts manufacturer, we plugged in their 6-digit code, and actually their definition of a small business is 1,500 employees or less. So they were actually able to qualify even though they were well over 500 because they were small under this code. So just because you don't have, if you're not under 500 employees, it doesn't necessarily mean that you're disqualified. You actually may be eligible. You have to plug in this code and see if it gives you a little bit more bandwidth to have more employees. Now that said, there's this affiliation rule. Beware. Affiliates are included in the calculation. So one of the issues we're running into is we have a number of companies who would normally qualify. They could be under 500 employees. They could be under 1,500 employees and qualify under the code. But if they have, for example, a foreign parent, let's say they're owned by a company in Germany or owned by a company in Japan or China, this is maybe not the best expression, but you're kind of guilty by association for eligibility purposes. So if you had 300 employees, okay, in the United States, and you are a small business, in my opinion, for United States purposes, but your parent in Germany, who owns the majority of your company, has 2,500 employees, for eligibility purposes, those 2,500 employees in Germany count towards your number. So that would take someone who would normally qualify as a small business, and it takes them right out of eligibility purposes right off the bat. So it really depends on your code. It depends on the ownership structure, and it depends on how many affiliates are kind of in your corporate structure tree. So that's something that, go ahead, Justin.
Bernie, one point to be made is that this is not just about affiliation with foreign parents. Most companies that are owned by private equity are also going to have a problem here because they're going to be lumped together with all of the portfolio companies in the private equity portfolio.
Absolutely. So again, you have to, whether it's foreign or domestic, you really have to look at your corporate organization structure, who are affiliates, parents, brothers, sisters. Look at that and count the kind of employees together for eligibility purposes. And again, Justin, myself, and Brett, offline, if you have this kind of nuanced situation, we can help you navigate that and see if you do qualify in a way. And even then, one of the things we have, folks, you may qualify and be eligible under the Act after going through this entire analysis. But from a practical standpoint, especially with the bigger banks right now, if there's a foreign tie even if you still meet the definition, some of the bigger banks are just refusing to take applications with that foreign affiliation. So you have to be careful with that. That's just, again, it's not in the act, it's not in the guidance. People are asking us, wait a minute, we meet the criteria, we are eligible, but there's just a practical issue with the banks right now. They're overrun, they are just way too busy, and they're taking the position, especially the bigger ones, that, hey, go somewhere else, which is just wild and crazy in and of itself, and we can get into that in a second. Another thing, this will obviously apply to sole proprietorships and independent contractors out there. A key point, some clients have come to us and have said that, hey, can I start a new entity and apply for the loan? The answer to that is no. You have to have been in operation by at least February 15th, 2020. So how much of a loan can you get? Okay, let's say you're eligible. How much can you get? The maximum loan size is $10 million. Most of the clients we're dealing with aren't getting the full shebang there, and they have to go to the actual calculation itself. So it's right in the act, it's in the statute itself, but just to try to keep it simple, you take the average total monthly payroll costs over the last year, and you multiply that by 2.5. Now, there has been some confusion on what 12-month period you use. The banks and the applications and really the guidance now say you can pick. It can be your 2019 12-month average, or it could be your rolling 12-month average. So I've seen a lot of companies do both. Some companies are using the 2019. Some companies are going April 1st through March 31st, just a few days ago. What is eligible for payroll costs? That sounds great. What does that mean? Certainly it's your compensation. So the salary, the wages, the commission, the cash tips you pay your employees from a gross standpoint are included in the payroll cost. You can also include the payment for vacation, parental, medical, or sick leave. You can include severance. You can include health care benefits and the insurance premiums, and also state or local taxes if they're applicable. So again, that payroll cost definition is pretty darn broad to a certain extent. You can include all of these, and you take the average of that over 12 months, you multiply that by 2.5, and that is the amount that you would be eligible for a loan. Okay, so let's say you had a average payroll cost of $100,000 per month. You times that by 2.5, you can get up to $250,000 as a potential loan. Now there are some buts, okay, some things that are just not eligible. So if you have employees who make over $100,000, you cannot include the salary, the wages, the commissions above that $100,000 mark. So if you've got someone, a lot of commission folks who are making, $200,000-$300,000 a year, you can include them in your payroll cost analysis up to $100,000, but you got to cap them right there. Any salary wages above that number are not included. You would not get to include that in your payroll costs. Now that's separate from, let's say somebody makes $90,000, okay, and they have a benefits package with healthcare premiums, things like that, that if you average it out, it'd be $30,000. You don't got to cap that. That's a separate category. You can still include that in your payroll cost, those healthcare wages, those healthcare costs, insurance premiums, things like that. That wouldn't be dinged against you with that $100,000 cap. Certain taxes obviously are eligible. The compensation of employees, if you've got employees who are in Mexico or overseas, outside the United States, you can't include their compensation in that calculation. And then Brett can kind of touch on this later. The qualified sick and family leave, there was a credit that's allowed under the Families First Coronavirus Response Act. You can't include that. Let's say you get the loan. What can you use it for? Well, you can use it for those exact payroll costs for the period ending June 30th, 2020. You can use it to pay off the interest on any mortgage obligation. You could use it to pay your rent. So those of you who are, quote, mom and pop shops, end quote, and you've got rent obligations to your landlord, if you got this loan, you could actually use that money to pay off your rent. There's some caveats to that, some qualifiers, which Justin will get into. But in theory, the idea behind this was, hey, you can use this loan to pay your people and to pay mortgage interest and to pay rent and to pay utilities. And you could even use it to pay interest on other pre-existing debt obligations that were incurred before this whole mess started. But again, the main purpose of this program, of the act, is the Paycheck Protection Program. I mean, the words itself mean what they mean. So Justin will get into it right now in the forgiveness component, but the purpose of this is for you to get a loan to keep your employees employed. You've seen them on the news, you've seen them beyond. If you take the loan and you keep your employees employed and you don't reduce their wages significantly, okay? The idea is if you do that and you keep them employed and you keep them on your payroll instead of kicking them to unemployment through the end of June, you will have at least be eligible of what they're saying to have the entire amount forgiven, which means it turns into a grant and you're not taxed on that forgiveness. So it's a pretty good deal. It's the best deal out there. That's why it's popular. That's why people keep saying, is this really free money? And to a certain extent, it is, or at least that's the intended use. But there are some nuances that you really need to be aware of. The forgiveness piece, and that is where Justin is going to take over and kind of get into those things so you have an idea of what you're getting yourself into. Justin?
Thanks, Bernie. As Bernie said, the good news is that there are loans available under this program, and the additional good news is that you may, if you have a loan, qualify to have part or all of that loan forgiven. Now, a couple caveats as we get into this. There are still some areas that need further clarification. The CARES Act itself is 335 single-space pages, and it appears to have been put together in about 12 minutes. So as you might expect, there's a fair amount of confusion, some inconsistencies, some conflicts, and just a lot of what does that mean in this act. So some of these will affect the forgiveness program too. But basically, the forgiveness is available to the extent that you have certain qualifying costs, and the measurement period is the 8 weeks that follow the loan date. So you take the 8 weeks following the time you get the loan. You are, to the extent you have payroll costs, interest, rent, utility in that period, you can put those into your forgiveness amount. Now, I want you to note something. These are the 4 categories that Bernie just talked about for permitted uses. But when we're talking about loan forgiveness, interest on mortgages, rent, utility payments have to all be with respect to obligations that were existing before February 15th. So what the government essentially is saying, we will loan you money to pay any of these things regardless of when they were incurred, but you're only going to get forgiveness if they were already in existence. We're not going to let you go out and create new obligations and use the money and get forgiveness for those things. Now, another caveat that is not in the act anywhere, but in SBA interpretation, is that those last 3 categories, the non-payroll costs, cannot be more than 25% of the total forgiveness amount. So the 8-week period that I'm talking about is going to be mentioned in a few of the slides that follow. So keep that 8-week period in mind, because that's an important period. Okay, now remember that the payroll protection program is intended to, as its name says, to keep people employed and to support their pay. Therefore, there are certain things that if the employer does them, in terms of workforce reduction or payroll reduction, will limit the amount of the loan that can be forgiven. So the first category is workforce reduction. This is a pro rata reduction, and it's based on taking the amount that would otherwise be available for forgiveness and multiplying it by a fraction. The numerator of that fraction is the average monthly number of full-time equivalent employees the business has during that 8-week period. You then compare that to one of 2 other calculations to get the denominator of the fraction. There are two different periods you can compare it to, and the borrower can choose which of those two periods to use. The first period is February 15th to June 30th of last year, 2019. The second period is the first 2 months of this year. The employer can choose whichever one it wants, and really will want to choose the period when it had the fewest number of full-time equivalents. So let's use a quick example. Let's suppose your business has, during the 8-week period after you get the loan, an average of 75 FTEs. Let's suppose that in the last year period, February 15th to June 30th of last year, you had 100 employees. Your fraction is going to be 75 over 100, which means only 75% of the amount that would otherwise be forgivable will qualify for forgiveness. If instead you look at the first 2 months of this year and had only 75 employees, then your fraction is going to be 75 over 75 or 100%, meaning that the entire amount would still be eligible for forgiveness. You would not suffer any limit on the forgiveness. So you're going to want to choose the period that has the least number of employees of full-time equivalents as your denominator in this calculation. Okay, so the second thing that can wind up causing a reduction in the amount that can be forgiven is reduction in salary. Now, this is an area where there is a fair amount of confusion still because the statute is poorly written in this regard. But what the statute says is that you compare if there's a reduction of more than 25% during that 8-week period, then there is a dollar for dollar reduction in the amount of the loan that can be forgiven. Okay, so your first question is going to be, okay, 25% compared to what? The Act says that it's 25% compared to the amount the employee got paid in the previous full quarter. And this is an employee by employee calculation. So 25% of the previous quarter. Now, look, you're comparing 8-week period against a 12-week period. The previous quarter is going to be 12 weeks. The covered period, the operational period is 8 weeks. So 25% of that 12-week period is going to be a larger number. That actually works to the borrower's favor because it would allow a greater reduction. Another thing to keep in mind is that this only applies to reductions for employees who make not more than $100,000 annually. And in a minute, I'm going to talk about a nuance of that particular limitation that raises some questions and that maybe provides some opportunity for less of a problem when you're talking about forgiveness. Now, the real problem with this portion of the Act is that it doesn't really tell you what you use as your starting point for determining a reduction. It just says a reduction during the 8-week period of more than 25% compared to that prior quarter. But does that mean that the reduction has to occur during that 8-week period? That's what the Act seems to say, but it would seem to suggest that an employer could make a significant reduction prior to taking the loan and then use those funds during that period and not have a reduction in the amount of forgiveness because the reduction did not occur during the 8-week period. That doesn't seem to make a lot of sense compared to what the policy of the Act is, but that is what the language literally says. Okay, so now you say to yourself, well, I'm in trouble. Okay, I'm never going to get reduction because I've already laid people off or I've already reduced salary. Well, the Act actually says that if you have taken those acts and you reverse them, you eliminate the reduction by June 30, they will not be taken into account in determining the amount of forgiveness or the limitation on the amount of forgiveness. So that sounds like a real way to game the system, I suppose, because you say, well, I take the money now, I'll lay off all my employees, I'll bring them back on June 29th, and I don't have a penalty. Yes, but remember that these are just reductions to the amount of forgiveness. The amount of forgiveness itself is determined by your qualified expenditures, at least 75% of which have to be payroll costs. So if you're not paying your employees during this period, you're not going to have the raw material to get forgiveness in the first place. And this question about reducing the amount of forgiveness is going to be irrelevant because you're not going to have forgiveness to reduce. Mechanically, how do you go about getting forgiveness? You're going to have to provide specific documentation to support the expenditure. So payroll records, rent receipts, etc., will have to be provided. And who are they provided to? To your lender. The lender is the body that decides whether or not you will give forgiveness. They're supposed to make that decision within 60 days after application. Whether those deadlines can be observed is going to be a question, because there's been a crush of this. As Bernie mentioned, some the lenders have already said they're shutting down their program for a while because they can't keep up with the volume. But in any event, the SBA has had to delegate the authority because there's just too much volume for the SBA itself to handle. Here's an important point. Normally, if you owe money and that debt is forgiven, you have income, taxable income. It's the same as if somebody gave you the money, which of course you'd have to report as income, and then you used it to pay off the debt. The CARES Act says forgiven amounts of CARES Act loans will not constitute cancellation of debt income, do not have to be included in gross income. Now, we expect more clarification around this in the coming days. There's already been some from the SBA. There was a memorandum issued last Thursday, which was issued less than 12 hours before the program was supposed to start, which caused a lot of havoc within the program. And there was an FAQ that's been issued this week on some of these issues. So what if your loan is not forgiven? Well, remember, it's a loan to begin with, so it just continues as a loan. Now, the CARES Act sets forth certain parameters for the loan. The SBA has issued some clarification of that. So the CARES Act says the loan can be for not more than 10 years. The SBA has said the term is going to be 2 years. And the CARES Act says the interest rate will be not more than 4% per annum. The SBA has said 1%. And there are provisions for deferral of payment for a period. I want to conclude my portion of this presentation by talking about a couple of issues to pay attention to when we talk about forgiveness. The first is the mismatch in periods. So you might say to yourself, look, I'm going to keep my workforce in place and I'm not going to reduce pay, so I'll be able to get full forgiveness because my payroll costs alone will take up the loan. That's not necessarily true, because remember, the loan amount is based on 2.5 times your monthly payroll costs. That's essentially 10 weeks. The period that you're measuring is 8 weeks. So even if you keep your payroll constant, you're probably going to have a gap between the amount of the loan and the amount of payroll costs during that 8-week period. Remember also that you can use that gap. You can use other expenses, rent and utilities, etc., for soaking up some of that gap in order to get further forgiveness, but that can't be more than 25% of your total forgiveness amount. So you need to bear that in mind. The second thing is taxes. Now, this is an area where there's a lot of confusion. The definition of payroll costs, Bertie touched on this just briefly, says that it excludes amounts of FICA and income tax withheld from employees during the period of February 15th to June 30th of this year. And everyone is scratching their head saying, what in the world does that mean? So some commentators have suggested that what it means is that it's not an exclusion for calculating your loan amount, since you can use 2019 numbers, but when it comes to forgiveness, you have to back that out. You could only get forgiven for the net amount you pay employees. That would make no sense under the provisions or under the policy that underlies the CARES Act, but it would make some sense in terms of trying to construe the language. Now, fortunately, the SBA's FAQ that it issued earlier this week appears to say that no, that's not the case, and that we won't be excluding withholding amounts in determining forgiveness. But we are going to need some additional clarification on that. Now, obviously, the whole entire loan forgiveness process is something that's going to come in the coming months. Right now, everyone's dealing with just getting the loans, qualifying for loans, getting them issued. Then we're going to worry about forgiveness. But it is something to pay attention to moving forward if you're trying to figure out what's the ultimate impact of taking this money going to be on me, and how much of this loan can I get forgiven. Bernie, I don't know if you want to talk on this too. This is just the process. Whoops, we went just one slide too many. Okay.
Yeah, process, folks. Real quick, okay? 3 things that I'm telling all my clients to do. Number 1, contact your lawyers. Whether it's us or another lawyer, contact them. Eligibility questions, things like that, the forgiveness, we can help with that. Okay, so get them in line. That's the first pillar. Second pillar, contact your CPA and your bookkeepers. You got to do these calculations. They've got the numbers. Get those ready to go if you haven't done it already. And number three, you got to find a bank. Okay, I would normally say start with the bank that you currently work with. You're an existing customer. The problem with that is some of them are some of the bigger banks. Okay, and the bigger banks, a few of them aren't taking new applications, but I would contact your bank immediately if you haven't contacted them and see if they will take your application. If not, you got to find another bank. Okay, and that would probably be a smaller, a credit union or a small bank. They might have more bandwidth and want to take you on, but you have to find and go through those three pillars. Now, practically speaking, I want to rope in Brett Miller here. Hey, Brett, let's start with question number one. And we've got employers and people out there who have already RIFed, furloughed, or laid people off. And they're concerned that they won't be eligible for this program because they've already laid people off. So I guess question one to you, is that true?
That's a great question. And no, that's not true. The fact that you've had to lay people off, put people on a temporary leave, furlough, whatever you want to call it, do across the board pay cuts, all the steps that employers have been taking to try to save money, that does not disqualify you from applying for this loan for PPP. It is not a qualification criteria they're looking at. The only issue, as as Justin discussed, is how that plays into your forgiveness. So the purpose of the act is to get people back to work as soon as possible. And there's that 8-week period that begins with the loan proceeds. And that's what the government wants to look at. It doesn't disqualify you from getting the loan, but for forgiveness, you want to get everybody back up at their regular rate of pay and working again when you get the loan.
Brett, let's say they apply today. Let's just take that as for assuming purposes. They apply today, but the money hasn't been deposited. They don't get the money from the government yet, and they don't know when they're going to get it. Payday's coming up April 15th for most employers. If they've applied right now, but they don't have the cash flow to make payroll, or they've got to do a furlough or a layoff right now before that money hits, can they do that and still be eligible right now?
Yes, yeah, they can, and they'll still be eligible. And it's really the big debate a lot of employers are having. They have to survive. There's a cash crunch for a lot of businesses, and you've got to do what you've got to do until you get this loan money. And then the point being, once you get that money, it doesn't disqualify you if you have to do what you have to do now and furlough or put people on leave. But once you get it, the whole point is get everybody back up and running and put them on payroll.
All right, let's move on to question two, and this may be applicable to a lot of the folks on this call right now. This CARES Act, the PPP, it's kind of what they've been calling phase 3. If we go back to phase 2, the Families First Coronavirus Response Act and those new paid leave laws, what do the employers and businesses need to know? How do they reconcile phase 2 and this phase 3 and the crossover?
Sure, and just to remind everybody out there, we have a whole webinar and section on our website on the Families First Coronavirus Response Act if you need more information. But generally speaking, these are two paid leave laws that came out that apply to employers with under 500 employees. And the purpose being that for COVID-19 related reasons, employees can take paid leave and the employer can get it reimbursed through the government by withholding the payroll taxes, and then if needed, getting tax credits from the government to basically have the government subsidize this paid leave program. What the CARES Act says, though, is you can't double dip. So you can't use PPP money to pay for your employees to go on a FFCRA related leave, then also take the credit under the FFCRA. So you're really having the government pay twice for that leave. It doesn't work like that. The CARES Act expressly excludes it, which can create a bit of an accounting nightmare, but you have to basically use the mechanism under the FFCRA, the payroll withholding and the tax credit procedure that way to pay for any leave. You can't use that CARES Act money for it. So it's a bit complicated, but the the purpose is to shift. You use that program with the IRS. It's come out with the IRS Form 7200 and some instructions for the FFCRA. Use that mechanism. Don't use CARES money for that.
I want to jump to question 4 here. And Justin and I were actually talking about this before the webinar started. Here in Michigan, Governor Whitmer obviously issued that stay-at-home order that expires on Monday, April 13th. Okay. We think that today around 3 o'clock, she's likely going to extend that. But Brett, what do you tell the employers and businesses out there who have been ordered to basically shut down? They're not an essential service. They're not a critical infrastructure company. They're basically, everybody's at home. They can't operate right now. And that may be extended for a period of time here. Okay. Can they still take advantage of the CARES Act and the PPP loan?
Absolutely. Yeah, this is the design of this program, is to get people on payroll. So even if you don't have work for people to do because you're shut down or you've had to lay off, your manufacturer and OEMs have shut down, or the governor has issued a stay-at-home order that is really affecting your business, you can still apply. The point is you get the loan and you put people back on payroll, even if there's no work for them to do. You're still paying them essentially to sit home, and the government subsidizing it as a measure to sort of maintain the status quo through this COVID-19 crisis. And then theoretically, hopefully after 8 weeks, everybody's back up and running. But that's a common question, Bernie, is, hey, I don't have any work for my people to do, but I still pay them. And the answer is, yeah, that's the point. Bring them back on payroll, and and hope everybody comes back, because as you have a question here in number 3 about unemployment that is kind of the wild card in that calculus.
And let's go to that question 3. Okay. So I might flip the script on you a little bit here, but let's say a company doesn't apply for the CARES Act, or the CARES Act PPP program is just not enough money and they have to furlough folks. Okay. Can you talk about those enhanced unemployment benefits and how that may affect the decision, or at least give the businesses out there a better understanding of what those enhanced unemployment benefits are?
Yeah, sure. The CARES Act also contains a provision for, not just employers, but what employees can do if they are laid off or underemployed due to COVID-19 related reasons. And the basics of the program are that it gives employees $600 per week from the federal government, in addition to whatever you get from the state. So that would mean in Michigan, you get a maximum of $362 per week from the state, plus another $600 from the feds. You're making over $900 a week on unemployment under this program. It also even applies if you're underemployed. So the way that the state, or what we're hearing, the way it's going to work is if you've cut employee hours and they are entitled to underemployment benefits through the state, they can still get the $600. So there's, when you look at that, the $900 plus, $962 a week is about $24 an hour for workers. So if they are low wage workers to begin with, they are literally doing better on unemployment at this point in terms of a pure wage calculation.
Brett, let's talk about that. I actually just got a question offline on this, and I might be jumping ahead here, but let's just see if we can address the question right now. To your point, there are a lot of folks out there who would make more money doing nothing and being on unemployment than working for their current employer. So let's say you got an employer out there, one of our businesses, they take the loan, they want to bring people back, they've already let people go, but the person says, no thanks, I'd rather stay on the sidelines and make more money. And they can't actually bring that person aboard, and that affects their forgiveness calculation. Any kind of guidance you can give the employers out there, if someone, they're ready to hire everybody back, and basically the employees refuse because they're making more money doing nothing, how would an employer navigate that?
Yeah, it's a very common question, Bernie, and it's becoming a problem. So the best advice right now is, if you have this situation as an employer, you're telling everyone you're recalled, you're back to work, you've got the loan funding, you can put people back on payroll, announce that people are back, they're coming back to work effective whatever date. At that point, if they say, I don't want to come back to work, then you can warn them that, look, we have to respond honestly to any unemployment related inquiries. And therefore, if you don't come back to work, we have to tell unemployment that there's work available for you and that you are voluntarily not taking that work, which would potentially disqualify them for unemployment benefits and kind of force them to come back on payroll. But it's a battle. It's a bit of a conversation that a lot of employers are having back and forth with employees right now.
All right, thanks, Brett. We're going to take a few more questions, but really just some breaking news. And I got 2 breaking news points. There's what's here on the screen right now, but I just got wind here that the Republicans' proposal to add $250 billion to the PPP program has been blocked. So it's Congress. Who the heck knows what's going to happen? That could change within the next 30 minutes, but they've been trying to add more money to the program because they think they're going to run out of funds pretty soon. And they were trying to add it, and it's been blocked, at least for right now. We can't control that. You can't control that. I think the best advice we can give you is if you haven't applied yet, do your best to apply. The money's just not there. It is what it is, but the faster you apply, the better chance you have of getting some money. Some additional breaking news: Treasury and the Federal Reserve have announced some new expanded lending programs under the Act. This really applies to those folks who, if you're not eligible for the PPP, there still are some options for you through some lending and some refinance options, but those come with a lot of conditions. We're not going to get into it right now, but if you don't fall into the PPP program and you want to find out other options available to you, we're happy to address that offline. Again, you may qualify, and I inserted some slides here for your perusal, but if you're between 500 and 10,000 employees, you could apply for and get a loan with a very low interest rate, no principal interest due for the first 6 months. You could get that. It wouldn't be forgiven. It wouldn't be the free money, but there's a lot of strings attached. And I have not spoken to a client yet who wants to take this loan. Here's some of those strings if you look at the screen, but a lot of it requires no outsourcing or offshoring of jobs, neutrality in union organizing and CBAs. Again, we don't need to talk about that right now, but I don't know any single client of mine who have not qualified for PPP, but who have applied for this loan. But it is an option if you want to talk about an option. So at this point, if you have questions offline, we at Butzel Long have a dedicated CARES Act assistance team. You see Justin's name there, myself and Brett Miller, but we also have other specialists at the firm who have been tracking the CARES Act along with us, whether it's tax, landlord-tenant issues, nonprofits, healthcare, retirements, you name it. We've got the team that can really jump in and help. So if you have questions like that, and obviously one size doesn't fit all, we're happy to help you and address that offline. So at this point, I can turn it over back to Brianna. If we have any questions, we can definitely jump in, Brianna, and try to answer some additional questions if anybody has them.
Perfect. Thank you so much. We do have a lot of great questions coming in, so I'm excited to hopefully get some clarification on this. We had one person chime in that says, when considering payroll costs, what about payroll fees in regards to they use a payroll company? How does that play in effect with the PPP?
Justin, you might be able to touch on this, but there was some guidance that you can, if you have a payroll provider, you can actually use that as well. So that doesn't disqualify you by any stretch of the imagination, if that's the substance of the question. Justin, any comments on your end regarding that, or Brett?
Yeah, that's on my end. I haven't seen anything else on that, Bernie. I think you're right. I mean, it's a pretty broad definition of those payroll costs.
Yep.
Okay, good to know. Another question was, how do you prove what you did with the PPP loan?
Well, that's in terms of the documentation, right? So it's they're trying to make this as simple as possible. So just On the application, the lenders have been instructed to rely essentially solely on the representations from the applicants. So as applicants, you are certifying that you're eligible. You are certifying that these are your payroll costs. You are certifying that you met the definitions and everything else. For forgiveness purposes, and Justin touched on this, you are going to apply for the forgiveness through your lender. And that's where you're going to have to bring in evidence and documentation to support not only the loan, but the forgiveness component. You're going to have your payroll records from 2019 and from this applicable 8-week period, if you're approved, to kind of reconcile. You're going to have the pay rates recognized. You're going to have documentation that you actually paid your landlords the rent, or you paid the interest on the utilities. You're going to have to basically show your work, if I put it in 5th grade terms. It's the honor system to a certain extent that you were eligible, and now you're going to have the documentation to prove and support that you actually used the money for what you said you were going to use it. And that includes the number of employees that you had during 2019 versus the number of employees that you employed and you paid during the 8-week period. So the documentation you have that you're going to apply for is going to be great. You should have that already. And then evidence to support what you actually used the money on for the 8-week period, you're going to have that ready to go and ready to submit to your lender in that 60-day period after June 30th.
Brianna, I think you have Justin muted and he may have some more comments, but this kind of goes back to Bernie's question about, when you have this FFCRA law and how you're using money, you can't use the money to pay for that, but some publications are even saying put this money in a separate bank account, because you have to account for this so specifically in many ways. And money is fungible, so how are you really tracking this stuff? And it's going to be a bit of a, like Bernie said, showing your work. It's going to be kind of important to track and document how this money was spent.
The interesting thing too, Brett, is that although there is a provision that says what the money can be used for, there's no enforcement mechanism. And when it comes to forgiveness, all they're looking for is whether you have qualifying expenditures. They don't really say that it came out of the funds. And obviously there's no way to prove that because, as you know, money is fungible. So for forgiveness purposes, the question is, do you have expenses that qualify under the various categories for forgiveness and in the right proportion? I don't know how they would go about enforcing the actual use of the money particularly. I suppose they could try to look at your other sources of revenue, and if you were suddenly taking, plane trips to Rio or something, they may ask questions. But I think it's more going to focus on the forgiveness, and in that regard, it's really just focused on whether you have the qualifying expenditures.
Thank you all for your clarification. I really appreciate that. We have a couple more questions coming in that I wanted to get some more information on. We had a company ask if they had employees that were laid off prior to the loan, are they now obligated to bring them back?
If they want the forgiveness, they need to bring them back. If they're going to use this money for payroll, they want to bring them back and maximize the percentage of forgiveness of this loan. And as Justin was kind of laying out that formula, if they don't do that, they can get this money and then they're going to end up having to pay a really good percentage of it back because they haven't put people back on payroll, which is the whole point of why Congress wants, to make this loan and have it forgiven.
Although, again, it's still a numbers game. So, from the workforce reduction, if you have laid employees off, but your workforce during your average number of FTEs during the 8-week period is still equal to what you had during one of those 2 earlier periods, then even though you laid people off in the interim, that won't affect your ability to get forgiveness. On the reduction in pay, that is still subject to so many questions that we can't answer that question with any level of real confidence right now until we get more clarification around what's the starting point for determining a reduction. So sorry not to be able to give a completely clear answer or definitive answer, but it is a numbers issue to some degree, and you may be able to have forgiveness without having brought employees back, but that's not a condition to getting a loan in the first place, right, Bernie?
That's absolutely correct.
Okay, great. Thank you again for the clarification. We had a question comment about what about healthcare expenses during this time?
Healthcare expenses is a broad term, but again, if in the calculation and the forgiveness, it's part of that, right? So if you've got health insurance premiums and healthcare costs that you pay for your employees, you can use that as a separate bucket in terms of calculating the loan amount. So if you pay X amount or you're self-funded and you pay those amounts during 2019, that pot of money is eligible for your calculation of the loan. And in turn, on the forgiveness component, and Justin, you can emphasize this with the forgiveness component, but if you keep your people employed and you continue to pay those same health care expenses and costs during the 8-week period, those healthcare costs are part of the forgiveness component. You can use the funds to pay those, to pay your premiums, to pay those expenses, and that would be eligible for forgiveness if you use those the right way.
Okay, so the definition of payroll costs, which we didn't necessarily get into in a lot of detail, but it includes payment required for provision of group health care benefits, including insurance premiums. Now, some people are uninsured, or self-insured, but those payments ought to qualify too. It's a payment for a group health benefit.
All right, thank you again. And we have one more question. It says, how do part-time employees count in the calculation?
Well, in terms of eligibility, it's kind of two questions. I'll break it up. To apply and be eligible for that 500 number and below, a full-time, a part-time, all count as an employee for number purposes. Okay. Now, the second part of that though is when it comes to forgiveness, and again, we're kind of getting into math, you get into FTEs, full-time equivalents. Okay. So if you had 2 employees during the calculation period who were 50%ers, and you had 2 employees who were 50%ers during the 8-week period, you're going to be fine. But it's really two different aspects. Again, number one, to be 500 and below, a full-time or a half-time counts as one head towards that 500 number. But for forgiveness purposes, the FTEs and the percentages all work on the math, both with the numerator and the denominator. I hope that makes sense. Maybe Justin could try to clarify too.
No, I agree with that. The FTEs do figure in. The forgiveness is based on FTEs. At least the reduction in forgiveness compares FTEs in the 8-week period with FTEs in the earlier period. So if you have part-time employees, you have to put in their equivalent number for FTE purposes. So if you had full-time employees in the earlier period and you reduce them to part-time employees in the 8-week period, they would not have the same value in both sides of the equation.
Okay, good to know. We're going to take one more question. And then, as I mentioned in the beginning of the webinar, all the questions that we weren't able to get to, either BBB or Butzel Long will be happy to help. So feel free to reach out. We're just going to take one more. The question that was submitted is, if they had to lay off their staff in the beginning of March, do they have to retro pay them, or can they start paying for the 8 weeks whenever they call them back?
I can take this. They do not need to retro pay them according to the language and the guidance that we've got to this point. So if you laid them off in early March, and they've been on unemployment, and you hire them back April 15th, you don't got to catch them up, so to speak, for those 6 weeks. As long as you employ them on the date you get the loan and you keep them employed for that 8-week period, the covered period, and you put them back to their salaries, although there's some wiggle room there, you should be in good shape. But there is no retroactive payment requirement at this point.
All right, great. Thank you all so much for your clarification. I want to thank all the participants for their questions. I want to send a huge thank you to Bernie, Justin, and Brett for your time. This presentation was extremely informational and beneficial to our members. So thank you so much to Butzel Long for sharing your expertise with us. And again, if your question did not get answered, my BBB or Butzel Long will be happy to help. Is there anything else, Bernie, Brett, or Justin, that you would like to add?
No, thank you very much.
Appreciate it, Brianna, and everybody else on the call.
Thank you all for your time, and I hope you enjoy the rest of your day.